Question 1. Implementation of the Arkansas Concealed Handgun Carry License, CHCL, application process requires careful attention to specific training mandates. Which of the following approaches best ensures an applicant meets the statutory requirements for obtaining a CHCL in Arkansas? Option A. Completing a firearms safety course that specifically covers Arkansas laws on handgun carry and the use of deadly force, taught by a certified instructor, and obtaining proof of completion. Option B. Relying on extensive prior military or law enforcement firearms training as a substitute for the mandated Arkansas CHCL safety course. Option C. Submitting an application with a statement of understanding of Arkansas handgun laws without formal training documentation. Option D. Attending any general firearms safety course, assuming it covers the necessary knowledge for concealed carry. The correct answer is A. Completing a firearms safety course that specifically covers Arkansas laws on handgun carry and the use of deadly force, taught by a certified instructor, and obtaining proof of completion. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for obtaining a concealed handgun carry license, CHCL, in Arkansas, which involves demonstrating proficiency and understanding of relevant laws. Misinterpreting or failing to meet these requirements can lead to denial of the license, impacting an individual's legal right to carry a concealed handgun. Careful judgment is required to ensure all steps are followed precisely according to Arkansas law. Correct approach analysis. The best professional approach involves diligently reviewing and adhering to the specific training requirements mandated by Arkansas law for a CHCL. This includes completing a firearms safety course that covers the legal aspects of handgun use and carrying, as outlined in Arkansas Code Title 5, Chapter 73, Subchapter 10. The applicant must ensure the course is taught by a certified instructor and that the curriculum meets all statutory requirements, including instruction on the laws of Arkansas governing the use of deadly force and the places where a handgun may be carried. This approach is correct because it directly addresses the statutory prerequisites for licensure, ensuring the applicant meets the legal standard for demonstrating competence and knowledge. Incorrect approach is analysis. An approach that relies solely on prior military or law enforcement experience without completing the mandated Arkansas CHCL training course is professionally unacceptable. While such experience may provide significant firearm proficiency, Arkansas law specifically requires completion of a certified safety course for all CHCL applicants, regardless of prior training or experience, as per Arkansas Code Section 5-73-309. Failure to meet this specific statutory requirement will result in denial. Another professionally unacceptable approach is to assume that any general firearms safety course is sufficient. Arkansas law specifies that the training must be a firearms safety course that includes specific instruction on Arkansas laws related to handgun carry and the use of deadly force. A generic course lacking these specific components will not satisfy the statutory requirements for a CHCL. Finally, an approach that attempts to bypass the training requirement by claiming ignorance of the law or by seeking an exemption not explicitly provided by Arkansas statute is also professionally unacceptable. The onus is on the applicant to be aware of and comply with all legal requirements for obtaining a CHCL. Arkansas Code Title 5, Chapter 73, Subchapter 10 does not provide for exemptions based on ignorance or informal requests. Professional reasoning. Professionals seeking a CHCL in Arkansas should adopt a proactive and meticulous approach. This involves thoroughly researching the most current Arkansas statutes and regulations pertaining to concealed handgun carry licenses. They should identify and enroll in a training course that is explicitly certified by the Arkansas State Police or a recognized state authority, and that covers all mandated curriculum points. Documentation of successful completion, including the instructor's certification and course details, should be meticulously maintained. This systematic process ensures compliance with legal mandates and maximizes the likelihood of a successful application. Question 2. To address the challenge of ensuring compliance with Arkansas concealed handgun carry laws when entering a private establishment that may have specific restrictions, what is the most responsible course of action for a concealed handgun carry license, CHCL holder? Option A. Rely on personal judgment regarding the safety of the environment to determine whether carrying a concealed handgun is appropriate, regardless of potential legal restrictions. Option B. Assume that carrying a concealed handgun is permissible in any private establishment unless there is explicit signage prohibiting firearms. Option C. Proactively research Arkansas Code, annotated provisions related to prohibited carry locations, and if unsure about the specific establishment's policies or legal status, refrain from carrying the concealed handgun into that location. Option D. Carry the concealed handgun and be prepared to explain to law enforcement that the establishment did not have any visible signs prohibiting firearms if questioned. The correct answer is C. Proactively research Arkansas Code, annotated provisions related to prohibited carry locations, and, if unsure about the specific establishment's policies or legal status, refrain from carrying the concealed handgun into that location. Explanation: this scenario presents a professional challenge because it requires an Arkansas Concealed Handgun Carry License (CHCL) holder to navigate a complex situation involving potential legal restrictions on carrying a firearm in a specific location, while also considering the safety and rights of others. The CHCL holder must exercise careful judgment to avoid violating Arkansas law and to act responsibly. The best professional practice involves a proactive and informed approach to understanding and adhering to all applicable laws regarding concealed carry. This means actively seeking out and verifying information about prohibited locations before entering them. Specifically, an Arkansas CHCL holder should be aware of and consult the Arkansas Code Annotated, ACA, concerning places where carrying a concealed handgun is prohibited. This includes, but is not limited to, ACA Section 5-73-306, which outlines various locations where carrying a handgun is unlawful, such as courthouses, schools, and correctional facilities, and ACA Section 5-73-122, which addresses carrying firearms in certain public buildings. Verifying the specific signage and policies of the establishment, and if in doubt, choosing not to carry the firearm into that location, is the most prudent course of action. This approach prioritizes legal compliance and minimizes the risk of unintentional violations. An incorrect approach involves making assumptions about the legality of carrying a concealed handgun in a particular establishment without verifying the specific regulations. Relying solely on the absence of explicit signage can lead to a violation if the location is otherwise legally restricted. Another incorrect approach is to assume that personal discretion or perceived safety justifies carrying a firearm in a prohibited area. Arkansas law does not permit such exceptions for CHCL holders in designated prohibited zones. Finally, ignoring potential restrictions or carrying a firearm into a location where it is prohibited, even if not immediately apprehended, constitutes a failure to uphold the responsibilities associated with holding a CHCL and a disregard for the legal framework governing concealed carry in Arkansas. Professionals should employ a decision-making framework that begins with a thorough understanding of their legal obligations under the Arkansas CHCL program. This involves continuous education on relevant statutes and any updates to the law. When faced with uncertainty about a location, the professional should pause, assess the situation, and actively seek clarification through official channels or by erring on the side of caution and choosing not to carry the firearm. This systematic approach ensures that actions are grounded in legal compliance and responsible conduct. Question 3. The review process indicates that an applicant for an Arkansas Concealed Handgun Carry License, CHCL, has a prior misdemeanor conviction for domestic violence. Which of the following approaches best aligns with the regulatory framework for issuing CHCL in Arkansas? Option A. Base the decision on general concerns about domestic violence and public safety, irrespective of the specific legal definitions of disqualifying offenses in Arkansas. Option B. Thoroughly review the specific nature of the domestic violence conviction and compare it against the disqualifying offenses listed in Arkansas Code Annotated Section 5-73-309 to determine eligibility. Option C. Grant the license without further investigation, assuming that all domestic violence convictions are automatically disqualifying under Arkansas law. Option D. Automatically deny the application because any conviction involving domestic violence is inherently disqualifying for a CHCL. The correct answer is B. Thoroughly review the specific nature of the domestic violence conviction and compare it against the disqualifying offenses listed in Arkansas Code Annotated Section 5-73-309 to determine eligibility. Explanation. The review process indicates a scenario where an applicant for an Arkansas concealed handgun carry license, CHCL, has a past misdemeanor conviction for domestic violence. This presents a professional challenge because the licensing authority must balance the applicant's right to apply for a license with the state's compelling interest in public safety and preventing the issuance of permits to individuals who pose a potential risk. Careful judgment is required to interpret the specific provisions of Arkansas law regarding disqualifying offenses. The best professional practice involves a thorough review of the applicant's criminal history against the explicit disqualifying criteria outlined in Arkansas Code Annotated Section 5-73-309. This approach requires understanding that while a misdemeanor conviction for domestic violence is a serious matter, the specific statute dictates which offenses permanently disqualify an individual. In this case, Arkansas law, specifically ACA Section 5-73-309b, 1a, states that a person is disqualified if they have been convicted of a felony or a misdemeanor involving the use of a deadly weapon or the unlawful discharge of a firearm. A conviction for domestic violence, depending on its specific classification and the circumstances, may or may not fall under these direct disqualifications. The licensing authority must verify the exact nature of the conviction and compare it to the statutory language. If the conviction does not directly meet the criteria for permanent disqualification under ACA Section 5-73-309, the applicant may still be eligible, subject to other statutory requirements. This approach is correct because it adheres strictly to the letter of the law, ensuring that decisions are based on objective statutory criteria rather than subjective interpretation or generalized concerns about domestic violence. An incorrect approach would be to automatically deny the application solely based on the fact that the conviction involves domestic violence, without a detailed examination of whether the specific offense meets the statutory definition of a disqualifying misdemeanor under ACA Section 5-73-309. This is ethically and regulatorily flawed because it presumes guilt or risk beyond what the law explicitly requires for disqualification. It fails to uphold the principle that individuals are presumed innocent until proven guilty and that licensing decisions must be based on established legal standards. Another incorrect approach would be to grant the license without any further investigation into the nature of the domestic violence conviction, assuming that any such conviction is automatically disqualifying. This is also a regulatory failure, as it bypasses the statutory requirement to assess the specific offense against the disqualifying criteria. It could lead to the issuance of a CHCL to an individual who, by law, should be disqualified, thereby compromising public safety. A third incorrect approach would be to rely on general public perception or media reports about domestic violence to influence the decision, rather than the specific legal definitions and requirements of Arkansas law. This is ethically unsound and a clear violation of regulatory principles, as it introduces bias and subjectivity into a process that must be objective and legally grounded. The professional decision-making process for similar situations should involve 1. Identifying the specific statutory provisions governing the license application and disqualifying factors. 2. Conducting a thorough factual investigation into the applicant's background, focusing on the precise details of any past offenses. 3. Applying the relevant statutes to the gathered facts in an objective and impartial manner. 4. Documenting the decision-making process, including the rationale and the specific legal basis for approval or denial. 5. Ensuring that the decision is consistent with established legal precedent and administrative guidelines. Question 4. Examination of the data shows that an Arkansas concealed handgun carry license, CHCL, holder has recently relocated to a new residence within the state. The individual has not yet updated their address with the Arkansas State Police. Which of the following actions best upholds the legal and professional responsibilities associated with holding an Arkansas CHCL? Option A. Assume that updating their address with the Arkansas Department of Motor Vehicles will automatically update their CHCL information. Option B. Wait for the Arkansas State Police to send a notice to the old address before taking any action. Option C. Promptly submit a written notification of the address change to the Arkansas State Police within 30 days of the move. Option D. Continue using the old address on all official documents until the CHCL is due for renewal. The correct answer is C. Promptly submit a written notification of the address change to the Arkansas State Police within 30 days of the move. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas who has recently moved and is unaware of the specific requirements for updating their address. The challenge lies in balancing the legal obligation to maintain accurate information with the practicalities of relocation and the potential consequences of noncompliance. Careful judgment is required to ensure adherence to Arkansas law while managing personal circumstances. Correct approach analysis. The best professional practice involves proactively and promptly notifying the Arkansas State Police, ASPA, of the address change. This approach directly addresses the legal requirement outlined in Arkansas Code Annotated Section 5-73-309 F, which mandates that a CHCL holder must notify the ASP in writing of any change of address within 30 days of the change. This ensures the license remains valid and the holder is in compliance with state law, avoiding potential penalties. Incorrect approach is analysis. Failing to update the address and assuming the old address is sufficient for all official communications is a regulatory failure. Arkansas law specifically requires notification of address changes, and continued reliance on outdated information can lead to missed official notices from the ASP, potentially impacting the validity of the CHCL or leading to other legal issues. Waiting for the CHCL to expire before updating the address is also a regulatory failure. The law does not provide a grace period for address changes tied to license renewal. This approach neglects the ongoing obligation to keep information current throughout the license's validity period and could result in the holder being considered out of compliance. Assuming that a change of address with other state agencies, like the Department of Motor Vehicles, automatically updates the CHCL information is a significant regulatory failure. The CHCL is a distinct permit managed by the ASP, and information updates are specific to that agency. There is no automatic interagency data sharing for CHCL address changes, meaning the ASP would not be aware of the move without direct notification. Professional reasoning. Professionals in this situation should adopt a proactive compliance mindset. Upon any change of address, the immediate step should be to consult the relevant state agency's regulations, in this case, the Arkansas State Police for CHCL requirements, and follow their prescribed procedures for updating personal information. This involves identifying the specific notification method, written, online portal, etc., and the time frame for submission. Prioritizing legal compliance over assumption or delay is crucial for maintaining the integrity of one's license and avoiding legal repercussions. Question 5. Upon reviewing their Arkansas Concealed Handgun Carry License, CHCL documentation, an individual who recently relocated to a new residence within Arkansas realizes they have not updated their address with the Arkansas State Police. They are unsure of the exact time frame for reporting this change. Which of the following actions best reflects adherence to Arkansas CHCL regulations and professional responsibility? Option A. Immediately submit a written notification to the Arkansas State Police detailing the new address. Option B. Wait until the CHCL renewal period to update the address information. Option C. Conclude that the address change is minor and does not necessitate formal notification to the state police. Option D. Assume that since the CHCL is valid nationwide, an address change within Arkansas does not require notification. Correct answer is A. Immediately submit a written notification to the Arkansas State Police detailing the new address. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas who has recently moved and is unaware of the specific requirements for updating their address. The challenge lies in balancing the legal obligation to maintain accurate information with the practicalities of relocation and the potential consequences of noncompliance. Careful judgment is required to ensure adherence to Arkansas law while managing personal circumstances. Correct approach analysis. The best professional practice involves proactively and promptly notifying the Arkansas State Police of the address change. This approach directly addresses the legal requirement outlined in Arkansas Code Annotated Section 5-73-309 F, which mandates that a CHCL holder must notify the state police in writing of any change of address within 30 days of the change. This ensures the license remains valid and the individual is compliant with state regulations, demonstrating a commitment to responsible firearm ownership and adherence to the law. Incorrect approaches analysis. Failing to notify the Arkansas State Police of the address change until the license renewal period is a regulatory failure. Arkansas law specifies a 30-day window for notification, and waiting until renewal constitutes a violation of this requirement, potentially leading to penalties. Assuming that a change of address is not significant enough to warrant notification is an ethical and regulatory failure. CHCL is tied to the individual's current address for official communication and verification purposes. Ignoring this requirement undermines the integrity of the licensing system and the individual's legal standing. Believing that the CHCL is valid nationwide and therefore address changes are irrelevant to Arkansas law is a significant misunderstanding of state-specific licensing requirements. While a CHCL may have reciprocity in other states, the primary licensing authority and its regulations, including address notification, remain with Arkansas. This approach demonstrates a lack of diligence in understanding and complying with the laws of the issuing jurisdiction. Professional reasoning. Professionals should adopt a proactive approach to legal and regulatory compliance. When relocating, it is essential to research and understand the specific requirements of the issuing jurisdiction regarding address changes for any licenses or permits held. A systematic process of identifying all relevant authorities, reviewing their regulations, and submitting necessary notifications within the stipulated timeframes is crucial. This ensures continued legal standing and avoids potential legal repercussions. Question 6. When evaluating the responsibilities of an Arkansas concealed handgun carry license (CHCL) holder who has recently relocated to a new residence within the state, what is the most appropriate and legally compliant course of action regarding their address information? Option A. Assume that updating their address with their new local police department is sufficient to update their CHCL information. Option B. Wait until the CHCL renewal period to update the address, as it is not an immediate requirement. Option C. Disregard the address change notification requirement as long as they are still residing within Arkansas. Option D. Promptly submit a written notification of the address change to the Arkansas State Police within 30 days of the move. The correct answer is D. Promptly submit a written notification of the address change to the Arkansas State Police within 30 days of the move. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license (CHCL) holder in Arkansas who has recently moved and is unaware of the specific requirements for updating their address. The challenge lies in balancing the legal obligation to maintain accurate information with the practicalities of relocation and the potential consequences of noncompliance, which could include the revocation of their CHCL. Careful judgment is required to ensure adherence to Arkansas law while managing personal circumstances. Correct approach analysis. The best professional practice involves proactively and promptly notifying the Arkansas State Police, ASP, of the address change. This approach directly addresses the legal requirement outlined in Arkansas Code Annotated Section 5-73-309, which mandates that a CHCL holder shall notify the ASP in writing of any change of address within 30 days of the change. This ensures the CHCL remains valid and the holder is compliant with state law, demonstrating a commitment to responsible firearm ownership and adherence to regulatory obligations. Incorrect approaches analysis. Failing to notify the ASP of the address change, or waiting an extended period beyond the statutory 30 days, constitutes a violation of Arkansas Code Annotated Section 5-73-309. This oversight can lead to the ASP being unable to contact the license holder, potentially resulting in missed notifications regarding license renewal or other important updates, and could be grounds for disciplinary action, including the suspension or revocation of the CHCL. Attempting to update the address through a local law enforcement agency rather than directly with the ASP is also incorrect, as the ASP is the designated authority for issuing and maintaining CHCL records in Arkansas, and such an action would not fulfill the statutory requirement. Professional reasoning. Professionals in this situation should adopt a proactive and diligent approach to regulatory compliance. This involves understanding the specific requirements of their license, including any obligations related to personal information updates. When a change occurs, the immediate professional step is to consult the relevant statutes or regulations. In this case, Arkansas Code Annotated Section 5-73-309, and follow the prescribed procedure for notification. Maintaining accurate records with licensing authorities is a fundamental aspect of responsible licensure and demonstrates respect for the legal framework governing the activity. Question 7. The analysis reveals that an Arkansas Concealed Handgun Carry License (CHCL) holder is attending a private social gathering at a restaurant that serves alcohol. The restaurant has a sign at the entrance stating, "No firearms allowed." What is the most appropriate course of action for the CHCL holder to ensure compliance with Arkansas law and respect for private property rights? Option A. Carry the handgun concealed, assuming the CHCL permits carrying in such establishments and that the signage is merely a suggestion. Option B. Attempt to speak with the restaurant management to negotiate an exception to the no firearms allowed policy before entering. Option C. Comply with the posted signage by not carrying the handgun into the restaurant and making arrangements to secure it elsewhere, or by choosing not to enter the establishment. Option D. Carry the handgun openly, believing that this might be perceived differently by the establishment and potentially avoid conflict with the signage. The correct answer is C. Comply with the posted signage by not carrying the handgun into the restaurant and making arrangements to secure it elsewhere, or by choosing not to enter the establishment. Explanation. The analysis reveals a scenario where a concealed handgun carry license (CHCL) holder in Arkansas is faced with a situation requiring a nuanced understanding of their rights and responsibilities regarding carrying a handgun in a private establishment that serves alcohol. The professional challenge lies in balancing the legal right to carry with the property owner's right to prohibit firearms on their premises, and understanding the specific legal ramifications of noncompliance. Careful judgment is required to avoid potential legal entanglements and to uphold both personal rights and the rights of private property owners. The best professional practice involves a clear understanding and adherence to Arkansas law regarding carrying handguns in establishments that serve alcohol. Specifically, Arkansas Code Section 5-73-306 outlines prohibitions and exceptions. The correct approach is to recognize that, while a CHCL holder may generally carry a handgun, there are specific locations where carrying is prohibited, and private establishments have the right to post signage or otherwise communicate their prohibition. Therefore, if an establishment clearly prohibits firearms, the CHCL holder must comply with that prohibition to avoid potential legal consequences, such as being asked to leave or facing charges if they refuse. This approach prioritizes legal compliance and respect for private property rights. An incorrect approach would be to assume that a CHCL automatically grants the right to carry a handgun in any location, regardless of posted signage or the owner's wishes. This demonstrates a failure to understand the limitations and responsibilities associated with a CHCL. Another incorrect approach is to believe that the right to carry supersedes the property owner's right to prohibit firearms, leading to a confrontation or refusal to comply with a posted prohibition. This disregards the legal framework that allows private property owners to set rules for their establishments. A further incorrect approach involves misinterpreting the signage or assuming a verbal prohibition is not legally binding, which can lead to unintentional violations of the law. Professionals should employ a decision-making framework that begins with a thorough understanding of the relevant Arkansas statutes governing concealed carry. This includes researching specific prohibitions related to locations like establishments serving alcohol and understanding the rights of private property owners. For entering any private establishment, especially one where alcohol is served, a CHCL holder should look for signage indicating a prohibition of firearms. If such signage is present, or if a verbal prohibition is communicated by the owner or their representative, the professional decision is to comply by either leaving the firearm secured elsewhere or not entering the establishment. This proactive approach minimizes risk and ensures legal compliance. Question 8. Comparative studies suggest that individuals with concealed handgun carry licenses, CHCL, in Arkansas often face challenges when relocating. Considering the legal framework governing CHCL in Arkansas, Which of the following actions best reflects a professional and compliant response for a CHCL holder who has recently moved to a new address within the state? Option A. Continuing to use the old address on file until the CHCL renewal period. Option B. Promptly submitting a change of address notification to the Arkansas State Police. Option C. Believing that the address on the CHCL itself does not need to be updated as long as the license is valid. Option D. Assuming the local sheriff's office will update the address information automatically. The correct answer is B. Promptly submitting a change of address notification to the Arkansas State Police. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas who has recently moved and is unaware of the specific requirements for updating their address. The challenge lies in balancing the legal obligation to maintain accurate information with the practicalities of relocation and the potential consequences of noncompliance. Careful judgment is required to ensure adherence to Arkansas law while avoiding unintentional violations. Correct approach analysis. The best professional practice is to proactively and promptly notify the Arkansas State Police, ASP, of the address change in accordance with Arkansas Code Annotated Section 5-73-309. This approach directly addresses the legal mandate to keep the CHCL information current. By immediately reporting the change, the license holder demonstrates a commitment to legal compliance and avoids any potential for their license to be considered invalid due to outdated information. This proactive measure ensures that the ASB has the most current contact details, which is crucial for official communications and renewals. Incorrect approaches analysis. Failing to notify the ASB and assuming the old address is sufficient for renewal purposes is a regulatory failure. Arkansas law requires the license holder to inform the ASB of any change of address. Relying on the old address for renewal could lead to missed notifications and potential lapse of the license, or worse, a finding of noncompliance if the ASB attempts to contact the individual at the outdated address. Waiting until the renewal period to update the address without any prior notification is also a regulatory failure. While the address will eventually be updated, the law mandates notification of the change, not just at the time of renewal. This delay creates a period where the license holder is technically operating with outdated information on file with the state, which could have implications if law enforcement needs to verify their license status or contact them. Contacting the local sheriff's office instead of the Arkansas State Police to update the address is a procedural error and a regulatory failure. Arkansas Code Annotated Section 5-73-309 specifically designates the Arkansas State Police as the agency responsible for maintaining CHCL records and processing address changes. While local law enforcement may be aware of the move, they are not the designated authority for updating the official CHCL address, leading to a failure to comply with the proper notification procedure. Professional reasoning. Professionals in possession of a CHCL in Arkansas should adopt a proactive and diligent approach to maintaining their license. The decision-making process should prioritize understanding and adhering to the specific statutory requirements outlined in the Arkansas Code Annotated. When a change of circumstance occurs, such as a relocation, the immediate professional responsibility is to consult the relevant statutes and regulations to determine the required actions. In this case, the clear mandate is to inform the Arkansas State Police of any address change. This principle of direct and timely compliance with statutory obligations forms the bedrock of responsible CHCL ownership. Question 9. The investigation demonstrates that an Arkansas Concealed Handgun Carry License, CHCL, holder was observed carrying a handgun in a building that houses multiple government offices, including a social services agency, but was not explicitly posted with a "No Guns" sign. The licensee believed that the absence of a sign meant they were permitted to carry. Based on Arkansas law, what is the most prudent and legally compliant course of action for a CHCL holder in such a situation? Option A. Proactively research Arkansas Code Annotated Section 5-73-306 and any other relevant statutes to confirm if the specific type of government building is a prohibited location for concealed carry, and refrain from carrying until certainty is established. Option B. Assume that carrying a concealed handgun is permissible in any location not explicitly posted with a "No Guns" sign, as signage is the primary indicator of prohibition. Option C. Interpret the absence of a sign as an implicit invitation to carry, and proceed with carrying the concealed handgun while remaining vigilant. Option D. Rely on the informal advice of other CHCL holders who may have carried in similar locations without incident. The correct answer is A. Proactively research Arkansas Code Annotated Section 5-73-306 and any other relevant statutes to confirm if the specific type of government building is a prohibited location for concealed carry, and refrain from carrying until certainty is established. Explanation. The investigation demonstrates a scenario where a concealed handgun carry license, CHCL, holder in Arkansas may have inadvertently violated the law due to a misunderstanding of prohibited locations. This is professionally challenging because it requires the CHCL holder to exercise a high degree of diligence in understanding and adhering to complex legal restrictions, even when acting with no malicious intent. The burden of knowledge regarding prohibited places rests solely on the licensee. The best professional practice in this situation is to proactively and thoroughly familiarize oneself with all Arkansas statutes pertaining to concealed carry, particularly those outlining prohibited locations, and to err on the side of caution by avoiding carrying in any location where there is ambiguity. This approach is correct because Arkansas Code Annotated Section 5-73-306 clearly defines numerous locations where carrying a handgun is prohibited, regardless of whether the location is posted with signs. The law places the responsibility on the licensee to know these restrictions. Ethical conduct in carrying a firearm necessitates a commitment to understanding and respecting the law to ensure public safety and maintain the privilege of carrying a concealed handgun. An incorrect approach would be to assume that if a location is not explicitly posted with a "no guns" sign, it is permissible to carry a concealed handgun. This fails to acknowledge that Arkansas law prohibits concealed carry in specific locations by statute, irrespective of signage. For example, carrying in a courthouse, polling place on Election Day, or a correctional facility is illegal under Arkansas law even if no sign is present. Another incorrect approach is to rely solely on the advice of other CHCL holders or informal opinions, rather than consulting the official statutes. This is a failure of due diligence and can lead to unintentional violations of the law, as the advice received may be inaccurate or incomplete. Relying on personal interpretation of ambiguous situations without consulting the law is also professionally unacceptable, as it prioritizes personal judgment over legal mandates. Professionals should employ a decision-making framework that prioritizes legal compliance and public safety. This involves actively seeking out and understanding all relevant statutes and regulations, consulting official sources for clarification when in doubt, and making conservative choices to avoid potential legal infractions. A commitment to ongoing education regarding firearm laws and responsible carry practices is essential. Question 10. Analysis of a scenario where an Arkansas concealed handgun carry license, CHCL holder is found to be carrying a handgun in a prohibited location, as defined under Arkansas law for the first time. Based on Arkansas Code Annotated Section 5-73-306, what is the maximum potential fine this individual could face for this first offense? Option A, $1,000. Option B, $3,750. Option C, $5,000. Option D, $2,500. Correct answer is D, $2,500. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas by requiring the calculation of potential fines based on specific legal provisions. The challenge lies in accurately interpreting the relevant statutes and applying them to a given set of circumstances to determine the financial consequences of a violation. This necessitates a precise understanding of Arkansas Code Annotated Section 5-73-301, etc., which governs CHCL, and specifically the penalty provisions for carrying a handgun in prohibited locations. Misinterpreting these provisions can lead to incorrect financial assessments, impacting the individual's understanding of their legal obligations and potential liabilities. Correct approach analysis. The correct approach involves a meticulous review of Arkansas Code Annotated Section 5-73-306, which outlines the penalties for carrying a handgun in prohibited places. This section specifies that a first offense is a class of misdemeanor, and subsequent offenses are Class D felonies. A class of misdemeanor in Arkansas carries a maximum fine of $2, $500, and a jail sentence of up to 1 year. A Class D felony carries a maximum fine of $5,000, and imprisonment of 1 to 6 years. Therefore, to calculate the maximum potential fine for a first offense, one must identify the maximum fine associated with a class of misdemeanor. Incorrect approach is analysis. An approach that calculates the fine based on the maximum penalty for a Class D felony would be incorrect because it assumes a subsequent offense when the scenario specifies a first offense. This misapplication of the penalty structure leads to an inflated and inaccurate fine calculation. An approach that averages the maximum fines for a class of misdemeanor and a Class D felony is also incorrect. This method lacks any basis in the statutory framework, which clearly delineates separate penalty tiers for first and subsequent offenses. Averaging ignores the specific legal classification of the violation. An approach that solely considers the maximum jail sentence without factoring in the corresponding maximum fine is incomplete and incorrect. While jail time is a potential penalty, the question specifically asks for the calculation of the fine. Ignoring the monetary component of the penalty leads to an inaccurate answer. Professional reasoning. Professionals dealing with legal compliance, such as those advising individuals on CHCL regulations, must adopt a systematic approach. This involves 1. Identifying the specific statute or regulation applicable to the situation. 2. Carefully reading and understanding the precise language of the law, paying close attention to definitions, classifications, and penalty provisions. 3. Applying the facts of the scenario directly to the legal text, ensuring that the correct penalty tier or provision is selected. 4. Performing any necessary calculations based on the identified legal parameters. 5. Verifying the calculations against the statutory requirements. This methodical process ensures accuracy and adherence to the law, preventing misinterpretations and incorrect advice. Question 11. Consider a scenario where an Arkansas concealed handgun carry license (CHCL) holder is attending a private community event held at a local park pavilion. The event is open to the public, and while many families with children are present, the pavilion itself is not on school grounds, nor is it a courthouse, correctional facility, or law enforcement building. The pavilion is located in a public park, and there is no signage explicitly prohibiting firearms. Based on Arkansas law, what is the most appropriate course of action for the CHCL holder regarding their concealed handgun? Option A. Refrain from carrying the concealed handgun due to the presence of children, as this could be perceived as an unsafe environment. Option B. Cease carrying the concealed handgun because the event is a public gathering, and such gatherings are generally considered sensitive locations. Option C. Carry the concealed handgun, as the location is not explicitly listed as a prohibited area under Arkansas Code Annotated Section 5-73-306. Option D. Assume that any location with a significant number of children present is implicitly a prohibited area under Arkansas law. The correct answer is C. Carry the concealed handgun, as the location is not explicitly listed as a prohibited area under Arkansas Code Annotated Section 5-73-306. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an individual to navigate the intersection of personal rights, public safety, and legal obligations under Arkansas law concerning concealed handgun carry. The core challenge lies in accurately interpreting and applying the Arkansas Code concerning the permissible locations for carrying a concealed handgun, particularly when faced with a situation that is not explicitly defined as a prohibited area, but could be perceived as sensitive or potentially problematic. A nuanced understanding of the law, rather than a broad assumption, is critical to avoid legal repercussions and maintain public trust. Correct approach analysis. The best professional practice involves a thorough and precise understanding of Arkansas Code Annotated A.C. Section 5-73-306, which outlines prohibited places for carrying a concealed handgun. This approach requires the license holder to consult the specific statutory language to determine if the location in question is explicitly listed as prohibited. If the location is not explicitly listed, and the individual is not otherwise prohibited from carrying, then carrying a concealed handgun is generally permissible under Arkansas law, provided all other conditions of the CHCL are met. This approach prioritizes adherence to the letter of the law and avoids making subjective interpretations that could lead to violations. Incorrect approach is analysis. One incorrect approach is to assume that any location where children are present or where alcohol is served is automatically a prohibited area, even if not explicitly stated in A. Section 5-73-306. This is a misinterpretation of the law, which specifies particular types of establishments, e.g., schools, courthouses, correctional facilities, law enforcement buildings, polling places on election day, etc., as prohibited. While responsible gun ownership may lead individuals to exercise discretion in certain environments, the legal permissibility hinges on explicit statutory prohibition, not on general assumptions about safety or appropriateness. Another incorrect approach is to rely on hearsay or informal advice from others regarding prohibited locations. The Arkansas CHCL is a legal permit, and its use is governed by specific statutes. Personal opinions or interpretations from non-legal sources do not constitute legal authority and can lead to significant legal trouble if followed. The law is the sole determinant of permissible carry locations. Further incorrect approach is to cease carrying a concealed handgun in a location simply because it is a private business that has posted a sign prohibiting firearms, without verifying if such a prohibition is legally enforceable under Arkansas law for concealed carry permit holders. While private property owners can generally prohibit firearms on their property, the specific legal ramifications for a CHCL holder in Arkansas when encountering such signage, especially if the location is not otherwise statutorily prohibited, requires careful consideration of A. Section 5-73-306 and related statutes. However, the most direct and legally sound approach is to adhere to the explicit statutory prohibitions. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes legal accuracy and adherence to statutory requirements. This involves 1. Identifying the specific legal framework governing the activity, in this case, Arkansas CHCL laws. 2. Consulting the precise language of the relevant statutes, Section 5-73-306. 3. Avoiding subjective interpretations or assumptions not supported by the law. 4. Seeking clarification from official sources or legal counsel if there is any ambiguity. 5. Understanding that personal discretion is separate from legal permissibility. Question 12. During the evaluation of a concealed handgun carry license, CHCL, holder's decision-making process in Arkansas, consider a scenario where the licensee enters a private restaurant that serves alcoholic beverages for on-premises consumption. The establishment has not posted any signage prohibiting the carrying of firearms. What is the most prudent and professionally responsible course of action for the CHCL holder in this situation? Option A. Assume that carrying a concealed handgun is permissible and without potential negative consequences because no prohibitory sign is posted. Option B. Confront the establishment owner about their alcohol sales and the lack of a firearm prohibition sign. Option C. Exercise caution and consider refraining from carrying concealed, even in the absence of a prohibitory sign, due to the environment where alcohol is being consumed. Prioritizing de-escalation and community safety. Option D. Immediately leave the establishment upon noticing alcohol is being served, even if no prohibitory sign is present. The correct answer is C. Exercise caution and consider refraining from carrying concealed, even in the absence of a prohibitory sign, due to the environment where alcohol is being consumed, prioritizing de-escalation and community safety. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the concealed handgun carry license, CHCL, holder to exercise discretion and judgment in a situation where their right to carry may intersect with the rights and safety of others in a private establishment. The core challenge lies in understanding the nuances of Arkansas law regarding carrying firearms in private businesses that serve alcohol, particularly when the business owner has not explicitly prohibited firearms. The CHCL holder must balance their legal right to carry with the potential for creating an unsafe environment or violating implied permissions. Correct approach analysis. The best professional practice involves understanding and adhering to Arkansas Code annotated Section 5-73-306, which outlines places where a CHCL holder may not carry a handgun. Specifically, this statute addresses carrying in establishments licensed to sell alcoholic beverages for consumption on the premises. The correct approach is to recognize that while Arkansas law generally permits concealed carry, there are specific exceptions. If a private establishment licensed to sell alcohol for on-premises consumption has not posted a sign prohibiting firearms, the CHCL holder may carry concealed. However, the most prudent and ethically sound approach, even in the absence of a prohibitory sign, is to exercise caution and consider the environment. If the establishment is clearly serving alcohol and patrons are consuming it, a CHCL holder should err on the side of caution and refrain from carrying concealed to avoid potential misunderstandings or contributing to an environment where a firearm might be perceived as a threat, even if legally permissible. This approach prioritizes de-escalation and community safety over asserting a right in a potentially sensitive context. Incorrect approach is analysis. One incorrect approach is to assume that because no prohibitory sign is posted, carrying a concealed handgun is always permissible and without potential negative consequences. This fails to consider the spirit of the law and the potential for creating an unsafe or uncomfortable atmosphere for other patrons, especially in an establishment where alcohol is being consumed. While technically not violating a posted sign, it disregards the broader ethical responsibility of a CHCL holder to act in a manner that promotes public safety and avoids unnecessary alarm. Another incorrect approach is to immediately leave the establishment upon noticing alcohol is being served, even if no prohibitory sign is present. While caution is commendable, this action is overly restrictive and goes beyond the legal requirements of Arkansas law. It implies a misunderstanding of the specific prohibitions outlined in ACA Section 5-73-306, which focuses on the licensing of the establishment and the presence of a prohibitory sign, rather than the mere act of alcohol consumption by patrons. A third incorrect approach is to confront the establishment owner about their alcohol sales and the lack of a firearm prohibition sign. This is inappropriate and unprofessional. The CHCL holder's right to carry is governed by state law, and they do not have the authority to dictate business practices or signage requirements to private owners. Such an action could lead to unnecessary conflict and is outside the scope of responsible firearm ownership. Professional reasoning. Professionals should employ a decision-making framework that prioritizes legal compliance, ethical responsibility, and situational awareness. First, they must thoroughly understand the specific statutes governing firearm carry in their jurisdiction, including any exceptions or restrictions. Second, they should assess the environment for potential risks or sensitivities. Third, when in doubt, or when a situation presents a gray area, they should err on the side of caution and prioritize de-escalation and the safety of themselves and others. This involves considering not just what is legally permissible, but also what is prudent and responsible in a given context. Question 13. Research into the professional conduct of a licensed real estate agent in Arkansas who holds a concealed handgun carry license, CHCL, reveals a common scenario. The agent is scheduled to conduct an in-home showing for a prospective buyer at a private residence. The agent legally possesses a CHCL and intends to carry their concealed handgun for personal protection during the showing. Considering Arkansas law and best practices for real estate professionals, what is the most ethically sound and professionally responsible course of action for the agent? Option A. Refrain from carrying the concealed handgun during client showings to avoid any potential discomfort or misunderstanding, even though it is legally permissible. Option B. Inform the client in advance of the showing about their CHCL and their intention to carry a concealed handgun for personal safety, and obtain the client's explicit consent to do so while on their property. Option C. Assume the client is comfortable with the agent carrying a concealed handgun, as the property is not a legally designated prohibited place under Arkansas CHCL statutes, and proceed with the showing. Option D. Carry the concealed handgun without informing the client, as it is legal to do so in private residences in Arkansas for CHCL holders, and the client has not explicitly prohibited firearms. The correct answer is B. Inform the client in advance of the showing about their CHCL and their intention to carry a concealed handgun for personal safety, and obtain the client's explicit consent to do so while on their property. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas who is also a licensed real estate agent. The core conflict lies in balancing the individual's right to carry a concealed handgun for personal protection with the professional responsibilities and potential liabilities associated with conducting business in a client's home, especially when that home may have specific restrictions or sensitivities. The agent must navigate the legal framework of Arkansas CHCL laws, real estate professional ethics, and the practical implications of client interactions without compromising safety, legality, or professional reputation. Careful judgment is required to avoid violating any laws or ethical codes and to maintain client trust. Correct approach analysis. The best professional practice involves proactively and transparently communicating with the client about the CHCL and the intention to carry a concealed handgun. This approach involves obtaining explicit consent from the client before entering their private residence while armed. The agent should explain that carrying a concealed handgun is for personal safety and that they are legally licensed to do so in Arkansas. This transparency fosters trust and allows the client to make an informed decision about whether they are comfortable with the agent carrying a concealed handgun on their property. This aligns with the principles of professional conduct in real estate, which emphasize honesty, integrity, and client-centered service. Furthermore, it respects the client's property rights and their right to set conditions for entry into their home, even if those conditions are not legally mandated by Arkansas CHCL law for private property entry. Incorrect approaches analysis. Carrying a concealed handgun into a client's home without informing or obtaining consent from the client is professionally unacceptable. This approach violates the ethical principle of transparency and can erode client trust. The client may feel their privacy has been invaded or that their safety is compromised, even if the agent is legally licensed. This lack of communication can lead to misunderstandings, complaints, and potential legal ramifications if the client perceives the presence of the firearm as a threat or a violation of their property's implicit or explicit rules. Another professionally unacceptable approach is to assume that because carrying a concealed handgun is legal for a CHCL holder in Arkansas, it is automatically acceptable in all professional contexts without client consultation. This overlooks the nuances of client relationships and the agent's duty to act in the client's best interest, which includes ensuring their comfort and peace of mind. The agent's personal right to carry does not supersede the client's right to control their own property and feel secure within it. Finally, relying solely on the fact that the property is not a prohibited place, as defined by Arkansas CHCL law e.g., schools, courthouses, and therefore assuming consent is implied, is also an incorrect approach. While legally permissible in many private residences, this approach neglects the crucial element of client relationship management and the ethical obligation to ensure client comfort and consent in a professional capacity. Professionalism demands more than just legal compliance. It requires proactive communication and respect for client boundaries. Professional reasoning. Professionals in client-facing roles, particularly those involving access to private residences, must prioritize open communication, transparency, and client consent. When personal rights or practices, such as carrying a concealed handgun, intersect with professional duties, the decision-making process should involve 1. Identifying potential conflicts between personal rights/practices and professional obligations/client expectations. 2. Consulting relevant laws and ethical guidelines, in this case, Arkansas CHCL laws and real estate professional ethics. 3. Prioritizing client comfort, safety, and trust. 4. Proactively communicating with the client about any potentially sensitive practices. 5. Seeking explicit consent where appropriate. 6. Documenting any such agreements or understandings. This framework ensures that professional conduct remains ethical, legally compliant, and client-focused, thereby safeguarding both the professional's reputation and the client relationship. Question 14. Stakeholder feedback indicates a recurring scenario where individuals seeking to renew their Arkansas Concealed Handgun Carry License, CHCL, present expired licenses, and assert that their original training should suffice for renewal, even if the training occurred several years prior and the renewal requirements may have evolved. As a licensed CHCL instructor in Arkansas, how should you best address this situation to ensure compliance with state law and uphold professional standards? Option A. Accept the applicant's expired CHCL and a notarized affidavit attesting to their continued proficiency. Option B. Require the applicant to complete the current Arkansas CHCL renewal training course. Option C. Renew the license based solely on the applicant's original training certificate without further course completion. Option D. Advise the applicant to reapply for an initial CHCL and claim their previous training is sufficient for that initial application. The correct answer is B. Require the applicant to complete the current Arkansas CHCL renewal training course. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, instructor in Arkansas. The challenge lies in balancing the legal requirements for CHCL renewal with the ethical obligation to ensure all applicants meet the current standards, even if their initial training was under a previous, potentially less stringent framework. The instructor must navigate potential client dissatisfaction while upholding the integrity of the licensing process and public safety. Correct approach analysis. The best professional practice involves requiring the applicant to complete the current Arkansas CHCL renewal training course. This approach is correct because Arkansas law, specifically ARC, Code Ann, Section 5-73-309, mandates that an applicant for renewal must meet the same qualifications as an initial applicant. While the applicant may have held a license previously, the renewal process is essentially a reapplication for a license, and therefore, they must demonstrate proficiency under the current training standards. This ensures all licensed individuals possess the most up-to-date knowledge and skills regarding firearm safety, legal use of force, and conflict avoidance as defined by current Arkansas law and training requirements. Incorrect approaches analysis. Requiring the applicant to only submit their expired CHCL and a notarized affidavit stating they have maintained proficiency is incorrect. This approach fails to comply with ARC, Code Ann, Section 5-73-309, which requires completion of a training course for renewal. An affidavit does not constitute proof of current competency or knowledge of any updated laws or training protocols. Allowing the applicant to renew based solely on their previous training certificate without any additional course completion is also incorrect. This directly contravenes the statutory requirement for renewal applicants to meet current qualifications. It risks licensing individuals who may not be aware of recent changes in Arkansas law pertaining to concealed carry or who have not refreshed their practical skills. Suggesting the applicant can simply reapply for an initial CHCL without completing a renewal course and then claim their previous training is sufficient for the initial application is fundamentally flawed. This misinterprets the renewal process and bypasses the legal mandate for renewal training. It also potentially misleads the applicant about the requirements for obtaining a new license if their previous one has lapsed significantly. Professional reasoning. Professionals in this field should adopt a decision-making process that prioritizes strict adherence to statutory requirements. When faced with a situation involving license renewal, the first step is to consult the relevant Arkansas Code annotated sections governing CHCL, particularly those pertaining to renewal. If there is any ambiguity, seeking clarification from the Arkansas State Police or legal counsel specializing in firearms law is advisable. The instructor's duty is to the law and public safety, not solely to the convenience of the applicant. Therefore, any approach that deviates from the legally mandated training requirements for renewal must be rejected. Question 15. Benchmark analysis indicates that a licensed real estate agent in Arkansas, who also holds a concealed handgun carry license, CHCL, is meeting a new client at their residence for an initial property showing. During the conversation, the client expresses significant discomfort with firearms and states they would prefer no weapons be present in their home. What is the most professionally responsible course of action for the real estate agent? Option A. Immediately cancel the showing and inform the client that the agent cannot work with them due to their stance on firearms. Option B. Proceed with the showing while carrying the concealed handgun, as the agent has a legal right to do so under their CHCL. Option C. Offer to securely store the concealed handgun in the agent's vehicle during the showing, ensuring it is not accessible to anyone within the client's home. Option D. Conduct the showing while carrying the concealed handgun, but do not inform the client about it to avoid unnecessary concern. The correct answer is C. Offer to securely store the concealed handgun in the agent's vehicle during the showing, ensuring it is not accessible to anyone within the client's home. Explanation. Scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas who is also a licensed real estate agent. The core conflict lies in balancing the legal right to carry a concealed handgun with the professional responsibilities and potential liabilities associated with conducting business in a client's home, particularly when that home may have specific restrictions or the client expresses discomfort. Navigating this requires careful judgment to uphold both personal rights and professional ethics without compromising client trust or legal standing. Correct approach analysis. The best professional practice involves proactively addressing the client's concerns and respecting their property rights. This approach prioritizes client comfort and professional integrity. By offering to secure the firearm in a location outside the client's home, such as in the agent's vehicle, the CHCL holder demonstrates respect for the client's wishes and avoids potential legal entanglements or professional repercussions. This aligns with the ethical obligation of a real estate agent to act in the best interest of their client and to maintain a professional environment conducive to business. Arkansas law, while granting the right to carry, does not mandate carrying in all circumstances, especially when it may interfere with professional duties or client relationships. The agent's willingness to accommodate the client's request, while still maintaining the ability to carry legally, is a demonstration of sound professional judgment. Incorrect approaches analysis. One incorrect approach involves asserting the legal right to carry the concealed handgun into the client's home without further discussion, despite the client's expressed discomfort. This fails to acknowledge the professional duty to ensure client comfort and trust. While the CHCL holder may have the legal right to carry, this action could be perceived as disrespectful or intimidating, potentially jeopardizing the business relationship and violating the implicit understanding of professional conduct within a client's private residence. It also ignores the potential for implied consent or specific restrictions within the client's home that could create legal issues. Another incorrect approach is to immediately refuse to conduct the showing or to terminate the professional relationship due to the client's request. This is an overreaction that fails to explore reasonable accommodations. Professionalism requires attempting to resolve such issues before resorting to drastic measures. This approach demonstrates a lack of flexibility and a failure to prioritize client service, which are essential for success in the real estate profession. A further incorrect approach would be to conceal the fact that the CHCL holder is carrying a handgun while inside the client's home, even after the client has expressed concern. This constitutes a lack of transparency and could be seen as deceptive. If the client were to discover the concealed weapon, it could lead to a severe breach of trust and potential legal ramifications, especially if the client had previously expressed a desire for the agent not to carry. Professional reasoning. Professionals in client-facing roles, especially those involving access to private residences, must employ a decision-making process that prioritizes client comfort, trust, and adherence to professional ethical standards. This involves active listening to client concerns, understanding the legal rights and responsibilities associated with their profession and personal choices, and seeking mutually agreeable solutions. When a conflict arises between personal rights and professional obligations, the decision-making framework should lean towards preserving the professional relationship and ensuring the client feels secure and respected. This often involves compromise and a willingness to adapt one's personal practices to meet professional expectations, provided such adaptations do not violate fundamental legal or ethical principles. Question 16. The performance metrics show a significant number of Arkansas concealed handgun carry license (CHCL) holders have not completed their mandatory renewal training within the legally stipulated period. Considering the Arkansas Code Title 5, Chapter 73, Subchapter 10, which approach best ensures compliance and public safety while respecting licensee rights? Option A. The Arkansas State Police immediately suspends or revokes any CHCL upon discovering that renewal training documentation has not been submitted by the deadline, without prior notification or opportunity for the licensee to provide proof of training. Option B. The Arkansas State Police only initiates contact with licensees if a complaint is received regarding a potentially non-compliant individual, rather than proactively managing renewal processes. Option C. The Arkansas State Police relies on licensees to independently track their renewal deadlines and assumes continued compliance as long as the CHCL card has not officially expired, without actively verifying renewal training completion. Option D. The Arkansas State Police proactively sends renewal notices well in advance of the expiration date and follows up with licensees who do not submit proof of completed renewal training within the statutory timeframe, initiating license revocation procedures only after verification of noncompliance. The correct answer is D. The Arkansas State Police proactively sends renewal notices well in advance of the expiration date and follows up with licensees who do not submit proof of completed renewal training within the statutory timeframe, initiating license revocation procedures only after verification of noncompliance. Explanation: the performance metrics show a concerning trend in the number of concealed handgun carry license (CHCL) holders in Arkansas who have failed to complete their mandatory renewal training within the prescribed timeframe. This scenario is professionally challenging because it directly impacts public safety and the integrity of the CHCL program. Law enforcement agencies and the Arkansas State Police, ASP, are tasked with ensuring compliance with state statutes governing firearm carry, and a lapse in renewal training can create ambiguity regarding a licensee's continued eligibility and proficiency. Careful judgment is required to balance enforcement with due process for licensees. The best professional approach involves a proactive and systematic process of notification and verification. This entails the Arkansas State Police diligently maintaining accurate records of CHCL expiration dates and initiating timely, documented communication with licensees whose training is due for renewal. This communication should clearly outline the renewal requirements, deadlines, and the consequences of noncompliance, as stipulated by Arkansas law. Upon expiration, a thorough review of the licensee's status should be conducted, confirming whether renewal training has been completed and submitted. If training is incomplete, the ASB must follow the statutory procedures for license revocation or suspension, ensuring the individual is no longer legally permitted to carry a concealed handgun in Arkansas. This approach upholds the legislative intent of the CHCL program, which is to ensure licensees remain proficient and knowledgeable about applicable laws. Failing to proactively notify licensees about upcoming renewal deadlines is a significant regulatory failure. Arkansas law, specifically through the Arkansas State Police's oversight of the CHCL program, implies a responsibility to manage the licensing process effectively, which includes facilitating renewals. A passive approach leaves licensees vulnerable to unintentional noncompliance and undermines the state's ability to ensure all active CHCL holders meet current training standards. Another incorrect approach is to assume that a licensee is automatically compliant if they possess a valid CHCL, even if renewal documentation is missing. This ignores the statutory requirement for renewal training as a condition of continued licensure. The CHCL is not a permanent permit. It requires periodic renewal, including demonstrated proficiency through training. Finally, immediately revoking a license without attempting to verify if renewal training was completed, even if the documentation is delayed, could be an overreach and potentially lead to legal challenges. While swift action is sometimes necessary, the process must adhere to the specific procedural safeguards outlined in Arkansas law for license revocation. Professionals in this situation should employ a decision-making framework that prioritizes adherence to Arkansas Code Title 5, Chapter 73, Subchapter 10, Concealed Handgun Carry Act. This framework involves 1. Maintaining accurate and up-to-date records. 2. Implementing clear and timely communication protocols for renewals. 3. Establishing a verification process for completed training. And 4. Following established legal procedures for noncompliance, including due process for licensees. Question 17. System analysis indicates that an Arkansas concealed handgun carry license (CHCL) holder is stopped by a law enforcement officer for a minor traffic violation. What is the most appropriate and legally compliant course of action for the CHCL holder to take regarding their concealed handgun? Option A. Attempt to conceal the handgun further or deny its presence if the officer inquires about weapons. Option B. Remain silent about the concealed handgun until the officer specifically asks if the individual is carrying any weapons. Option C. Immediately reach for the concealed handgun to present it to the officer without any prior verbal notification. Option D. Immediately and verbally inform the law enforcement officer of the presence and location of the concealed handgun, while keeping hands visible and following all officer instructions. The correct answer is D. Immediately and verbally inform the law enforcement officer of the presence and location of the concealed handgun, while keeping hands visible and following all officer instructions. Explanation. System analysis indicates that a licensed concealed handgun carrier in Arkansas faces a professionally challenging situation when encountering a law enforcement officer during a routine traffic stop. The challenge lies in balancing the legal requirement to disclose the concealed handgun with the inherent personal safety concerns and the need to avoid escalating the interaction. Careful judgment is required to ensure compliance with Arkansas law while maintaining a calm and cooperative demeanor. The best professional practice involves immediately and verbally informing the law enforcement officer of the presence of the concealed handgun and its location, while keeping hands visible and following all instructions. This approach is correct because Arkansas Code Annotated Section 5-73-306 1. Mandates that a CHCL holder must, upon demand of a law enforcement officer, produce the license and inform the officer that the person is carrying a handgun. Proactive and clear communication, as outlined in this approach, directly fulfills this statutory obligation and demonstrates respect for the officer's duties, thereby minimizing potential misunderstandings and ensuring safety for all parties involved. An incorrect approach involves remaining silent about the concealed handgun until specifically asked by the officer. This failure to proactively inform the officer violates the explicit requirement in Arkansas Code Annotated Section 5-73-306. 1. To inform the officer that the person is carrying a handgun. This omission could be perceived as deceptive or a deliberate attempt to conceal information, potentially leading to an escalated and dangerous situation. Another incorrect approach is to immediately reach for the handgun to present it to the officer without verbal notification. This action, while potentially stemming from a desire to comply, bypasses the statutory requirement for verbal notification and can be misinterpreted by the officer as a hostile or threatening movement, significantly increasing the risk of a dangerous encounter. A further incorrect approach is to attempt to conceal the handgun further or to deny its presence if the officer inquires about weapons. This is a direct violation of Arkansas law and demonstrates a lack of integrity and cooperation. Such behavior undermines the trust between the public and law enforcement and carries severe legal consequences, including potential revocation of the CHCL and criminal charges. The professional decision-making process for similar situations should involve a thorough understanding of the specific legal requirements of the jurisdiction. In this case, Arkansas CHCL laws, prioritizing clear and immediate communication with law enforcement, maintaining a calm and cooperative demeanor, and ensuring hands are visible and movements are deliberate and non-threatening. The primary goal is to comply with the law while ensuring the safety of oneself and the officer. Question 18. Which approach would be most prudent for an applicant seeking a concealed handgun carry license, CHCL, in Arkansas who was arrested for a minor offense several years ago, but the charges were subsequently dismissed and the record was later expunged, and the application asks for a history of arrests? Option A. Only disclose the arrest if formal charges were filed and prosecuted, excluding instances where an arrest occurred but no charges were brought or where the record was expunged. Option B. Disclose the arrest but only if the applicant believes it reflects negatively on their character, otherwise omit it to avoid unnecessary complications. Option C. Omit any mention of the arrest from the application, as the charges were dismissed and the record was expunged, making it irrelevant. Option D. Fully disclose the arrest on the application, providing a brief, factual explanation of the circumstances and the dismissal, and include any supporting documentation if permitted by the application. The correct answer is D. Fully disclose the arrest on the application, providing a brief, factual explanation of the circumstances and the dismissal, and include any supporting documentation if permitted by the application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate potential ambiguities in their personal history and understand how those ambiguities might be interpreted under Arkansas law for a concealed handgun carry license, CHCL. A failure to accurately and completely disclose information, even if the applicant believes it is minor or irrelevant, can lead to denial of the license and potential legal repercussions. The challenge lies in balancing the legal obligation to disclose with the applicant's perception of what is significant. Correct approach analysis. The best professional practice involves a proactive and transparent approach to disclosure. This means the applicant should fully and accurately disclose all requested information on the CHCL application, including any past arrests, regardless of whether charges were filed, dismissed, or expunged, and provide any supporting documentation or explanation as permitted by the application process. Arkansas Code Section 5-73-309 A.1 requires applicants to provide information as prescribed by the Director of the Arkansas State Police. While the statute doesn't explicitly detail how to handle expunged records on the application itself, the general principle of full disclosure on government applications, especially those involving public safety, is paramount. The Arkansas State Police application form and associated instructions are the definitive guide for what information must be provided. If the applicant is unsure about the necessity of disclosing a specific event, they should err on the side of caution and disclose it, providing a brief, factual explanation. This approach demonstrates honesty and a commitment to complying with the spirit and letter of the law, minimizing the risk of misrepresentation. Incorrect approaches analysis. One incorrect approach is to omit any mention of the arrest because the applicant believes the charges were minor and dismissed, and they have not been convicted. This is a failure to provide complete information as required by the application process. Arkansas law, through the state police's prescribed application, aims to gather a comprehensive history to assess an applicant's suitability. Omitting relevant information, even if seemingly minor, can be construed as an attempt to conceal information, leading to denial. Another incorrect approach is to only disclose arrests where charges were formally filed and prosecuted, excluding instances where an arrest occurred but no charges were ever brought. This is also a failure to provide complete information. The arrest itself is a significant event that the licensing authority may wish to review, regardless of the subsequent prosecutorial decision. The application's intent is to understand the applicant's interactions with law enforcement. A third incorrect approach is to assume that an expunged record does not need to be disclosed on the CHCL application. While expungement may seal records from general public view, it does not necessarily exempt them from disclosure on specific government applications, particularly those related to public safety and licensing, unless explicitly stated by the governing authority. The Arkansas State Police application instructions are the ultimate authority on what must be disclosed, and failing to disclose a potentially relevant event, even if expunged, could be seen as a misrepresentation. Professional reasoning. Professionals should always advise clients to be completely truthful and thorough on all application forms, especially those for licenses that involve public safety. The decision-making process should involve 1. Thoroughly reviewing the specific application form and all accompanying instructions from the Arkansas State Police. 2. Advising the applicant to disclose all requested information, including any arrests, dismissals, or charges, regardless of their perceived significance or expungement status. 3. Encouraging the applicant to provide brief, factual explanations for any potentially concerning disclosures, rather than attempting to omit them. 4. Emphasizing that misrepresentation or omission on an application can have severe consequences, including denial of the license and potential legal penalties. Question 19. Investigation of an Arkansas Concealed Handgun Carry License, CHCL, applicant's background reveals a past misdemeanor conviction for simple assault that occurred 10 years prior to the application. The applicant has otherwise met all training and residency requirements and has no other criminal history or mental health adjudications. Which of the following represents the most appropriate course of action for the licensing authority in Arkansas? Option A. Request a psychological evaluation of the applicant to assess their current temperament due to the past assault conviction. Option B. Conduct a thorough background check to determine if the simple assault conviction is a disqualifying offense under Arkansas Code Annotated Section 5-73-301 et sec., considering the nature of the offense and the time elapsed since its occurrence. Option C. Issue the CHCL, assuming that a misdemeanor conviction from a decade ago is unlikely to pose a current risk. Option D. Immediately deny the CHCL application based on the presence of any criminal conviction, regardless of its nature or age. The correct answer is B. Conduct a thorough background check to determine if the simple assault conviction is a disqualifying offense under Arkansas Code Annotated Section 5-73-301 et sec., considering the nature of the offense and the time elapsed since its occurrence. Explanation: investigation of a concealed handgun carry license, CHCL, applicant's background in Arkansas, presents a professionally challenging scenario due to the sensitive nature of firearm ownership and the legal requirements for licensure. The challenge lies in accurately interpreting and applying Arkansas Code, annotated Section 5-73-301, et sec., and related administrative rules to determine eligibility. Balancing public safety with individual rights. Careful judgment is required to avoid both erroneous denial of a lawful permit and the issuance of a permit to an unqualified individual. The best professional practice involves a thorough review of all submitted documentation and a comprehensive background check, strictly adhering to the statutory disqualifiers outlined in Arkansas law. This includes verifying the applicant's age, residency, completion of required training, and absence of any disqualifying criminal convictions or mental health adjudications as specified by statute. This approach is correct because it directly implements the legislative intent of the Arkansas CHCL program, which is to permit responsible citizens to carry handguns for self-defense, while ensuring that individuals who pose a risk to themselves or others are not licensed. Adherence to these specific statutory criteria is the only legally sound and ethically responsible method for determining eligibility. An approach that relies solely on the applicant's self-reported information without independent verification of criminal history or mental health status is professionally unacceptable. This fails to meet the statutory requirement for a background check and creates a significant risk of issuing a license to someone who is legally disqualified, thereby undermining public safety. Another professionally unacceptable approach would be to deny a CHCL based on unsubstantiated rumors or personal biases about the applicant's character, rather than on specific statutory disqualifiers. This violates the principle of due process and the requirement for objective, evidence-based decision-making mandated by Arkansas law. Such an approach is arbitrary and discriminatory. Finally, an approach that prioritizes speed of processing over thoroughness, leading to a cursory review of the application and background check, is also professionally unsound. This demonstrates a disregard for the serious responsibility of licensing individuals to carry firearms and can result in overlooking critical disqualifying factors, jeopardizing public safety. Professionals in this field should employ a systematic decision-making framework that begins with a complete understanding of the relevant Arkansas statutes and administrative rules. This framework should include a checklist of all statutory requirements and disqualifiers, ensuring each is addressed for every applicant. Documentation should be meticulously reviewed and background checks conducted through official channels. Any ambiguities or potential disqualifiers should be investigated further, with decisions made based strictly on the legal criteria, not on subjective opinions or external pressures. Question 20. Assessment of a concealed handgun carry license, CHCL holder in Arkansas, who is aware that a public elementary school's property extends 100 feet from the main building, needs to determine the minimum distance they must be from the school building to ensure they are not carrying a concealed handgun on the school's prohibited premises. If the CHCL holder is standing 150 feet from the school building, what is the minimum distance they must be from the school's property line to be in compliance with Arkansas law regarding carrying a handgun near a school? Option A, exactly 150 feet from the school building. Option B, any distance that feels safe from the school building. Option C, at least 1 foot beyond the school's property line. Option D, within 100 feet of the school building, as that is the distance to the property line. Correct answer is C, at least 1 foot beyond the school's property line. Explanation: scenario analysis. This scenario presents a professional challenge for a concealed handgun carry license, CHCL, holder in Arkansas by requiring them to calculate the minimum safe distance from a designated gun-free zone based on specific legal parameters. The challenge lies in accurately applying the statutory distance requirement to a real-world situation, ensuring compliance with Arkansas law to avoid potential legal repercussions. Misinterpretation or miscalculation could lead to unintentional violations of the CHCL regulations. Correct approach analysis. The best professional practice involves a precise calculation of the minimum distance required by Arkansas law. Arkansas Code annotated Section 5-73-306, A. 1. A. specifies that a CHCL holder may not carry a concealed handgun into a place where the person knows or has noticed that the handgun is prohibited. While the statute doesn't explicitly define a buffer zone around all gun-free zones, common interpretation and best practice for safety and compliance dictate maintaining a reasonable distance to ensure the handgun is not considered on the premises of the prohibited area. For a school, which is a prohibited location under Arkansas Code annotated Section 5-73-306, A, Roman 4. A common-sense interpretation of on the premises often extends to the immediate surrounding property. Therefore, calculating the distance from the property line of the school is the most prudent approach. If the school's property extends 100 feet from the building, and the CHCL holder is 150 feet away from the building, but within the property line, they are still considered on the premises. The correct calculation would be to determine the distance from the absolute edge of the school's property. If the school's property line is 100 feet from the building, and the CHCL holder is 150 feet from the building, they are 50 feet from the property line. However, the law requires the handgun to not be on the premises. A conservative and legally sound approach is to ensure the CHCL holder is a minimum distance beyond the property line. If the property line is 100 feet from the building and the CHCL holder is 150 feet from the building, they are 50 feet from the property line. Be definitively off the premises. A distance beyond this is necessary. A calculation that ensures the individual is a specified distance away from the property line is the most accurate. For example, if the property line is 100 feet from the building and the individual is 150 feet from the building, they are 50 feet from the property line. To be safe, they should be at least, for example, 101 feet from the building to be 1 foot past the property line. The calculation should focus on the distance from the property boundary. Incorrect approach is analysis. One incorrect approach is to simply measure the distance from the school building itself, ignoring the extent of the school's property. This fails to account for the full definition of on the premises as it relates to school grounds, which are also considered a prohibited area. This could lead to the CHCL holder being within the prohibited zone, even if they are a certain distance from the building. Another incorrect approach is to estimate the distance without any calculation. This introduces subjectivity and a high risk of error, potentially placing the CHCL holder within the prohibited zone without their knowledge. The law requires a clear understanding of prohibited areas, and estimation does not meet this standard. A third incorrect approach is to assume that any distance from the building is sufficient, regardless of the property boundaries. This demonstrates a misunderstanding of how gun-free zones are legally defined and enforced, which typically includes the entire property associated with the institution. Professional reasoning. Professionals must adopt a proactive and meticulous approach to understanding and applying the laws governing their CHCL. This involves not only memorizing the rules, but also understanding how to practically apply them in various scenarios. When dealing with prohibited areas, it is crucial to identify the exact boundaries of these zones and calculate distances with precision, erring on the side of caution. This requires consulting the relevant statutes and, if necessary, seeking clarification from legal counsel or law enforcement to ensure full compliance and avoid unintentional violations.